Dr. Laura Beckman is the visiting scholar for the Pennsylvania Commission on Sentencing and the Criminal Justice Research Center. She graduated from Arizona State University with a PhD in Criminology and Criminal Justice and is currently an associate professor in the Department of Criminal Justice at Shippensburg University. Her research focuses on assessing racial and ethnic disparity in courts, sentencing, and juvenile justice. For her current project with the Pennsylvania Commission on Sentencing, she is collecting data on Pennsylvania county processes regarding community supervision, treatment, and sentencing. Welcome, Doctor.
Well, thank you very much for having me. I was honored to be asked to apply for this position and then be selected. And I'm just going to give a little bit about my research background, which broadly examines racial and ethnic inequality in court sentencing and the juvenile justice system. So one example of my work would be that I had recently looked at how race and ethnicity influence internal attribution, the perceptions of internal attributions, and internal attributions in turn lessen the likelihood of youth receiving diversion. And so how I got into this type of work was that I had worked with at-risk youth in Pennsylvania, and then also with my master's degree, the program was sociologically focused. So I had been exposed to research on social inequality, and together it kind of formed my research agenda for both my PhD and then my assistant professorship. And so this kind of led into my work with the Pennsylvania Commission on Sentencing, which is looking at contextual differences in county level processes. And so I'm going to talk about two studies that I conducted regarding contextual inequality, and then I'm going to talk more about my current project with the Pennsylvania Commission on Sentencing. So the first study that I'm going to talk about was recently published, and then the second one is a work in progress. So the first one is about is titled Revising the Minority Threat Perspective, Examining the Main and Interactive Effects of Segregation on Sentencing. And then the second study is on the federal court processing of immigration cases and the contextual factors that go into decision making. All right, so the overarching theoretical frameworks that I used for both studies, first was the minority threat perspective, which posits that as minority groups size grows, the majority population feels threat, can perceive a threat to their economic resources and political resources, and that in turn they enact formal social control such as sentencing, harsher arrest rates. And then the second theoretical framework is courts as communities, which looks at how courts operate as social worlds, and the people within the courts interact to form substantive rationalities. That's fine. All right, so the second framework that I use for the two studies is courts as communities, which looks at courts as their own social worlds in which actors interact with each other, and then they also interact with the outside environment, and these interactions form substantive rationalities that, as policies are imposed, can impact how those policies are adhered to. And then the third theoretical framework that I used is the focal concerns perspective, which looks at how decision makers orient around the focal concerns of blameworthiness, protection of the community, and practical constraints of the community, and how stereotypes can actually inform or impact perceptions of blameworthiness and dangerousness. And this within context of where there is a perceived threat, these stereotypes can be amplified. All right, so for this first study, the problem that I looked at is that within the minority threat and sentencing literature, there has been a lot of research that has accumulated that has shown that there is, and it's been really mixed regarding sentencing. And so Omar in 2012 called for the literature to move beyond simplistic linear relationships and to move towards looking at the conditions and other factors that might be involved regarding the minority threat perspective. And one of the issues that had been neglected in the past within the sentencing literature is segregation, racial and ethnic segregation, and how they may play a role in shaping sentencing decisions. And this is important because segregation may act as a means of informal social control because it contains what separates interactions between racial and ethnic groups and limits their interactions with each other. So in that regards, formal means of social control and might not be as necessary and or seen as necessary or perceived as necessary. And so the prior research on segregation and other criminal decision points showed that segregation does have an impact at policing, and sometimes this can be contradictory. Some research has shown that it has mitigated the formal social control, and in others it's actually amplified it. And it has theoretical implications for the minority threat perspective, as well as policy implications, because it would indicate that there's another factor that might create contextual inequality within decision making. And so the study investigated the main and interactive effects of racial and ethnic segregation on sentencing decisions. So there are three hypotheses. There's racial and ethnic segregation will reduce sentencing severity, that racial and ethnic segregation will reduce the positive impact of racial and ethnic composition on punitive sentencing, and then racial and ethnic segregation will reduce any racial and ethnic disparity in punitive sentencing. And so the data was pulled from the multiple different sources. For contextual level data, the main independent variable was the index of dissimilarity, which looks at evenness between counties, and a 100 would mean that it's completely segregated. Counties are completely segregated to the point where 100% of people would have to move to another county for there to be complete evenness between race and ethnicity. And then other data for the control variables was pulled from the 2000 US Census LEAPS Atlas of US presidential elections, this National Center for State Courts, and then the Uniform Crime Reports. And then on the right-hand side is all the individual level data, which was from the state court processing statistics. All right, so the dependent variables that were examined were the decision to incarcerate and sentence length. So the decision to incarcerate had non-custodial sanction was a reference category, and then jail and prison were both examined separately. And then sentence length was logged, and zeros were assigned 0.1 because it was skewed. All right, so the independent variables consisted of percent Black, racial segregation, percent Hispanic, and then ethnic segregation. And then there were cross-level interactions. So at the individual level, there's also whether the defendant was Black and whether the defendant was Hispanic. So then county level control variables were resource deprivation, percent voted for Bush, UCR crime rate, sentencing guidelines, state and county jail capacity. And then there were a host of individual level controls, which are listed, but if you'd have any question of those about those, I can go over them. All right, so I used hierarchical multinomial logistic regression for the decision to incarcerate, and then hierarchical linear regression for sentence length, and then predicted probabilities of marginal effects of racial and ethnic composition by racial and ethnic segregation were also calculated, in which the control variables were held at the mean, and then low segregation was one standard deviation below average, then it was average, and then one standard deviation above average. All right, so looking at the first table, can see that racial segregation decreased the likelihood of receiving a prison sentence, but this relationship was curvilinear. And I have a figure that represents this relationship that I'll go over in a little bit. And then regarding sentence length, racial segregation also decreased sentence length. All right, so here in figure 1, you can see that jail, the predicted probabilities for jail slightly increase from low to average segregation and then rapidly decline to high segregation, whereas for prison, it's a modest decline, and then for non-custodial sanctions, it's it rapidly increases, going to high segregation. And then this shows the predicted probabilities looking at average percent Black and high percent Black across different levels of racial segregation, and the impact of percent Black diminish on prison, the likelihood to incarcerate decreases when in moving from low to average and to high segregation. And so then the next set of analyses looks at ethnic segregation, and ethnic segregation main impact is on jail sentencing. So ethnic segregation decreases the likelihood of a jail sentence, and then also and has no impact on sentence length. Right. So then if you look at figure 2, you can see this relationship where non-custodial sanctions increase, as well as prison, but there's no significant difference between the two. And then jail rapidly decreases. Right. And then looking at the predicted probabilities here, it's a similar relationship as racial segregation, except it's within jail sentencing, in which when moving from average and high percent Hispanic, that relationship is reduced at average segregation and high segregation. All right, so when moving from average to high segregation, the predicted probabilities are 0.385 and 0.301 over average and high percent Hispanic. And then, and so study one shows that racial and ethnic segregation play mitigating factors in sentencing decisions. And there's differences in the way this manifests regarding racial segregation versus ethnic segregation. So racial segregation mainly impacted the decision to incarcerate for prison sentences, whereas ethnic segregation mainly sentencing. And this shows the necessity to parse out jail and prison sanctions, but also it shows that racial and ethnic segregation play a role, but not always a consistent role. And this supports, well, this coincides with the previous research on the minority threat perspective, which has been not always consistent, and shows that it's necessary to look at the different conditions in which it does impact social control. And so one of the areas for future research that I'd be interested in regarding this study is looking at how segregation, looking at segregation longitudinally, and then looking at its impact on perceptions of threat, and how how impacts perceptions of threat over time. And so this study kind of brings to light another factor that may produce contextual inequality. And so this brings me to the second study. So the second study that I looked at was part of a broader study assessing racial and ethnic disparity in immigration offenses. And so there are three parts to this. There's cumulative disadvantage within immigration cases. And then the second study was contextual disparity within immigration offenses. And then the third one was disparity in sentencing of immigration offenses over time. And the reason why I had looked at this is because immigration offenses have increasingly made up a larger portion of federal offenses. So there has been a lot of punitive rhetoric surrounding immigration, even though it's been inconsistent with research on the immigrant paradox. And a lot of this has been a lot of the punitive rhetoric is rooted in moral panic and scapegoating on documented immigrants for economic issues and terrorist issues, and has really increased the criminalization of immigration. And because comprehensive immigration reform hasn't been successful, the focus has turned to law enforcement of immigration cases. And this has resulted in constraints on the court through an increasing number of immigration cases coming into federal courts, and then has, because of the constraints and the zero tolerance policies and the increased enforcement, the criminal justice system has intersected with the civil system and what has been termed crimigration, and it has diminished the protections afforded immigration defendants in federal court processing. And so examples of this, when being Mirandized, somebody who might be questioned for both a civil and criminal offense might be asked the question first time without Mirandizing them, and then asking them the second time. And so with Mirandizing them, but asking them the same question. And so in the first round of questioning, they've already incriminated themselves. And the second way this might play out is in bail hearings, which are often conducted in big groups, or somebody who is a defendant in an immigration case might be placed into the civil system and detained there for long periods of time, and that can become a means to detain the person even if they're released from bail within the criminal justice system. And then early disposition is a fast track program where the person gives up a lot of their due process protections in return for, it's usually like a 4-level sentencing departure, but it speeds up the process and diminishes their due process. All right, so the one issue is that the immigration cases have increasingly made up a large portion of federal cases, but a lot of times they've been neglected in examining them because they are unique and they have difficult aspects for analysis, such as that the fast track programs, constraints with demographic and variation, and the intertwining with the civil system. And so there have been a few studies that have examined immigration cases and then have also looked at contextual factors, but haven't really focused on the racial and ethnic context and how that may influence. And that's important because immigration offenses are one of the largest category of offenses in federal court, and it's important to assess whether disparity exists because it speaks to the fairness of the system, but also the punitive rhetoric surrounding undocumented immigration may make the cases particularly susceptible to harsher sanctioning in districts where there's a larger growing Hispanic population. And so this study investigates whether ethnic composition of federal court districts impacts multiple court outcomes for immigration offenses. So the second study examines whether percent Hispanic, absolute change in percent Hispanic, percent foreign-born, absolute change in percent foreign-born, and cross-level interactions with ethnicity, whether they result in harsher treatment for all defendants, and then Hispanic defendants in particular over multiple court outcomes. And so the individual level data was pulled from the Federal Justice Statistics Program data series. It put together a cohort of defendants arrested and booked between 2004 and 2010, and it linked the U.S. Marshals data with the Executive Office of U.S. Attorneys, with the Administrative Office of U.S. Courts, with the U.S. Sentencing Commission data. And so incoming cohort at case filing, there were 308,668 cases, but after being filed into magistrate court, those cases filtered out, and then there were 110,769 filed into district court, and then the linking system, about 102,274 cases matched from the case filing or the Executive Office of U.S. Attorney data with the Administrative Office of U.S. Courts. And then, so the outcomes that I look at is based on the U.S. Sentencing Commission and data, and it's pre-sentence detention, early disposition, charge reduction, guideline departure, and then sentence length. And the contextual data was pulled from the U.S. Census Bureau 2000-2010, the LEAPS Atlas of U.S. Presidential Elections, Uniform Crime Reports, and National Judicial Center. And there's 90 U.S. district courts. And then early disposition analysis is only on those districts with early disposition programs. So it was restricted to non-citizens. And then immigration cases, because illegal entry usually go to magistrate court, they make about 7%, whereas illegal reentry 77%, citizenship fraud 1%, and then other is 15%. And so pre-sentence detention is looks at whether someone was detained or not detained. Early disposition is whether whether a defendant received early disposition or no early disposition. Charge reduction is whether it looked at statutory severity. And so if there are 5 primary charges, and then it looked to see whether that was reduced.
Yeah, an excellent job. That's fascinating.
Thank you. I apologize, everyone. We had a little bit of IT problems today, and Laura, you're doing great hanging in there with us.
Yeah, I don't know if there's anything that you would like to see, because I did put together, there's a lot of information.
We can provide the PowerPoints to everyone after through our website, but I think for now, because of time, it's best to just keep going where you were and let people see. Now that we're up to the results, I think it's good we were able to get this going right now.
Okay.
Okay, so just keep your flow going. You're doing great.
Okay. All right. So the independent variables were percent Hispanic squared, absolute change in percent Hispanic, and then Hispanic ethnicity, because I did also include percent foreign born. However, there weren't any statistically significant results with that, so I'm excluding that from the results that I'm going to show. Here are the individual level control variables for each stage. And I'm happy to go over those if you have questions about that. And then the contextual level control variables. Similar to the other study, conservative district, resource deprivation, index crime rate, caseload rate, court size. For the outcomes in which it wasn't early disposition, I used the full sample, and so I controlled for whether it's located in a fast track district, for example, for pre-sentence detention, and then whether it's located in a Southwest border district. So the analytic strategy, because white Hispanic defendants make up overwhelming proportion of the sample, I conducted a random subsample, which is about 20%, and then about 18,363 cases remained after that random subsample, and that was so that I could use white non-Hispanic as the reference category, and then there's multi-level modeling with defendants at level 1, districts at level 2, and then binary logit was used for the binary variables with multinomial logistic for guideline departure, and then ordinary least squares for the sentence length. So here you can see the results from the second study. So percent Hispanic impacted pre-sentence detention in a curvilinear manner in which it increased, detention increased and then leveled off. And then the absolute change in percent Hispanic interacted with ethnicity, but Hispanic defendants were less likely to receive pre-sentence detention as the absolute change increased. And then with early disposition, the early disposition increased linearly as percent Hispanic increased and absolute change in percent Hispanic increased. All right, so then downward departure had a similar relationship as pre-sentence detention when it came to the interaction between absolute change in percent Hispanic and ethnicity. So Hispanic defendants were less likely to receive pre-sentence detention when absolute change increased. All right, and then there were no significant effects in sentence length. All right, so the theoretical implications, there's limited and mixed support for the minority threat perspective in the second study. But what we do see with the early disposition is crimigration. So the results might seem like, because early disposition is actually lenient in the fact that it's fast tracking people through the system and giving them a departure, it's also it's problematic because it's really fast justice, and it's associated with diminished civil rights. And so the fact that this increased as percent Hispanic increased is not surprising, given that the reason these programs came about was to address constraints. And then also, if you think about it in a punitive manner, it's increasing the crimigration of the court and making the criminal justice system more enmeshed with the civil system. But then with pre-sentence detention, we see that similarly that it reaches a threshold point and then levels off, which is what the minority threat perspective that is consistent with the form that you would expect, in which at some point the minority population eclipses the majority population. But it could also be, because we don't have qualitative data or the processes that are going on, it could also be that they're using the civil system detention more as more cases are coming in. And then also the leniency for Hispanic defendants. I didn't have baseline threat, so I'm not sure what the starting point was, and that could be something that to look at in the future. Are they more lenient? Is the system more lenient when it's high and then goes higher, or the baseline is high and then the percent change increases? Or is it, some studies have found, like with new destinations, which it's hard to look at with federal district courts because you can have different types of immigrant destinations within the same court or within the same district. but that literature shows that people might perceive a threat when there's fewer people or fewer immigrants within the area, or fewer Hispanic people within the area, because then it actually amplifies perceptions of differences. And so those are some of the limitations that I would like to, this is a work in progress that I might want to look at in the future. And this brings me to my work with the Sentencing Commission, because one of the future directions that I would really like to look at, and which becomes apparent with the results of this study, is that there needs to be more information on the processes. So the missing link is courts as communities. And I mentioned that at the beginning, in which they form these substantive rationalities that are the product of interactions between courtroom work group and then also their outside environment. So I was looking at the very broad environment, but there's also the immediate and situational environment as well that needs to be considered. And this can impact not only how policies that are imposed on the courtroom actors, how strictly they adhere to them, or how they interpret them, but it can also impact how open they are to implementing policies or their processes within the courts. And so when I had worked with or had a lot of talks with the director, Mark Bergstrom, and then the deputy director, Dr. Kleinman, and the research manager in analytics, Brett Miller, the repeated theme that we had talked about was the necessity for looking at contextual inequality, but then looking at these courts as communities and looking at their processes. And so I finished a data collection instrument, and we're going to be looking at the back end after sentencing. And some of the issues that we're going to be looking at, or that I'm going to be collecting data for, includes the pretrial services and whether courts have a pretrial services division, the types of services they offer, types of bond, whether the courts use a risk assessment tool, how open they are to risk assessment tools, how they implement it, the type of assessment tool that they use, looking at intake process and screening tools, looking at the court size, collecting data on the number of judges, prosecutors, public defenders, and whether they're full-time, and then looking at types of specialized caseloads, protocols, how those are assigned, and then looking at resources within the area, and the range of services that can be offered, relationships with the community, how case plans are created, treatment goals, types of problem-solving courts, whether those problem-solving courts are certified, and how probation violations are treated, how the guidelines are used, how they're interpreted, how a second offense is handled, both how it would be handled as a new offense, and then also how it would be handled by whether it's the same judge or a separate judge. I would look at that. And so I created an instrument, and now I'm in, well, it's not necessarily an instrument, it's a data collection, and it's a list of an inventory of items. And right now I'm in the process of contacting counties. So the first one is Cumberland County, because I live right next to the courthouse. So that makes it accessible. And also I know some of the people within the probation department as well. And so we're also going to some other areas might be grant funding, the costs of services. And so these are just the main domains that I'm looking at, but there's a lot more items that will be going underneath those domains. All right, and so thank you again for having me, and I appreciate your.
I think we've got a couple Q&As here.
Yeah.
So let's end your slideshow and come back here to our presentation and do our there. Out of there. Sharing. Start our video. There we are. Okay. So I want to check my Q&A, and if I have no open questions, sometimes we get some. I was wondering, maybe Megan has a question for you. She's obviously recruited you to be one of our speakers. Megan, do you have a question for? Let's see her there. Okay, well then I do not have any Q&As at this time. We really appreciate you coming up on somewhat of an iffy day when it came to weather. And thank you for the last minute switch. I'm sorry the projector didn't work in the other room, but you handled it really well coming in and presenting. Is this something that could be shared with folks later on? Okay, because I'll have an email of the people that have attended, and I could send them the PowerPoint if they'd like to see your data. Okay. All right. Thanks so much for joining us today. This was recorded, so the first half of it is you speaking, but the second half will have your data, and then people could probably merge that information. All right. Thank you.
And thank you, Laura and Joy, for dealing with all the technical difficulties we had today. I know this made this a little more stressful than perhaps we would have liked. So thank you so much for hanging in there. And please get home safely before this storm hits.
Oh, and ice, right.
Yeah.
Thank you, Dr. Kurlichek.
Yeah, thank you.
And thanks for coming up. Bye now.